until we are live streaming. All right, good morning. Welcome to the First District Court of Appeals. We have two cases to be argued this morning. The first is Robert Gehring as treasurer versus Kenneth Shane Scott. Ms. Daly, you will have 15 minutes to argue this morning. Whenever you're ready, I will keep your time.
Thank you. Good morning, Your Honors, and may it please the court. My name is Jessie Daly on behalf of the appellant, the Hamilton County Treasurer. This matter is before the court for consideration of the disposition of excess funds remaining after the judicial sale of delinquent real estate. It is our position that the lower court incorrectly applied the law when determining that the appellee was entitled to the excess funds at issue in this case. As such, this court reviews these issues de novo. Instead of dispersing the excess funds to the appellee, those funds should be forfeited to the Delinquent Tax and Assessment Collection Fund, here the Land Bank, pursuant to 57-2120. Forfeiture to the Land Bank is the correct course of action for two reasons. First, the appellee received all notice of which he is entitled under the law. And second, the appellee failed to make a timely demand to the excess funds as is required under 57-2120.
What is the notice that is required under the law?
The notice that is required under law, yes, Your Honor. Notice went out of the complaint by certified mail to the appellee, and that was evidenced by a signed return receipt. And notice went out of the excess funds after the judicial sale, also to the same address to the appellee. That was sent out by certified mail. That certified mail came back unclaimed, so it was reissued by regular mail. This court stated in its 2018 decision in Altman v. Parker that where—
I noticed you didn't dispute the trial court's determination on notice.
We believe that notice was done in accordance with the civil rules governing service of process. The appellee did receive all proper notice. However,
that as an assignment of error?
The lower court incorrectly applied the law when determining that the appellee did not receive proper notice of the excess funds, because when the plaintiff follows the civil rules governing service of process, courts presume that service is proper unless the defendant rebuts that presumption with sufficient evidence of proper service. Here, the treasurer strictly adhered to Civil Rule 4, because when the certified mail came back undelivered, we issued service by regular mail. So therefore, it's presumed proper.
Why did the court find that there wasn't proper notice?
Quite frankly, Your Honor, I was a little uncertain on that. In her opinion, the judge went through and said, well, you must have got notice of this because you appeared here, and you must have got notice of this because you appeared here. But I found that you didn't get actual notice. So frankly, Your Honor, it was a little confusing, the opinion, I thought. Unfortunately, I was not at that hearing. I was not assigned to this case at that time. But reading the opinion, it was a little uncertain.
So it's not supported. Her finding, your argument is not supported by the record.
That's correct, Your Honor. If you'll look at the docket, which is also circumstantial evidence of whether service was proper, you'll see that all service went to the same address at 617 Worcester Pike. So certified mail of the complaint, like I said, that was evidenced by a signed return receipt. And although we didn't get a signed return receipt for the notice of the excess funds, that did not ever come back unclaimed. Additionally, the treasurer's motion for forfeiture, that was also sent to 617 Worcester Pike. And in the record, the lower court does state that the appellee must have gotten notice of that because he did appear before the magistrate to dispute that motion. Even further, the magistrate's decision was sent to 617 Worcester Pike, and the appellee did file objections. So he must have received that decision at that opinion. And interestingly enough, in his objections, he lists 617 Worcester Pike as his address.
Now, wasn't it within 3 years from the time of the filing of the regular notification to the date that that Mr. Scott came to, basically said, hey, I want to receive any notification on the sale or on the case?
It was not.
Wasn't that within 3 years?
It was not, Your Honor. So the notice of the excess, let me see, excuse me, the deposit of the excess funds was made on June 29th of 2017.
No, what I'm saying, wasn't it 3 years from the date of the regular mailing of service to the date that Scott notifies?
So I'm not sure I'm understanding your question. The 572120 calls for the appellee to make a demand for the excess funds within 3 years from the date of the deposit of those excess funds.
And where is those excess funds to be deposited?
So there was discrepancy in the lower court on that issue. The statute calls for the funds to be deposited with the treasurer. However, the lower court found they are currently held with the clerk. And the lower court found that that was okay because it substantially complied with the statute. And the reason that those funds are maintained with the clerk as opposed to being transferred to the treasurer is because it essentially saves time and money for the appellee.
Doesn't the statute use the word shall? And when we are construing statutes, shouldn't we give meaning to the word shall?
It does, Your Honor. It does call for shall. And to that point, it also says that if the funds are not demanded within 3 years, they shall be forfeited to the land bank. We did not raise that issue on appeal because the lower court found that it was not an issue, and they found that it did substantially, the treasurer's behavior did substantially comply with the statute.
The case that the court relied on, how is that relevant to this case? Because the court basically said, hey, strict compliance is not, and there wasn't any prejudice. And there was a statute that actually applied to that case that was the language that seemed like the court was relying on, that allowed for certain deviations if there's no prejudice. We don't have such statute that applies in this case. So how is that case relevant? And how can we get around the word shall?
Your Honor, I apologize. I am not certain on the facts at issue in that case that she relied on. That was not an issue that we raised on appeal. Our appeal mainly focused on whether he received adequate notice and whether the demand was made timely and what should happen when that demand is not made timely. I'd be happy to review that case and provide a supplemental brief, but at this point, I apologize. I am not up to par with the facts in that case to answer that question.
Let me ask a follow-up question to that. With respect to where the funds were deposited, and I don't want to put words in your mouth, but I think what I heard was it doesn't really matter to Mr. Scott whether the funds were held at the clerk's office in escrow or at the treasurer's office, that the trial court found the location of the funds was not relevant because either way it didn't affect his claim. Am I right about what she found?
That is correct, Your Honor. In no way is the appellee prejudiced by where the funds are being held. In fact, it actually benefits him because when the funds are held with the clerk, they are more accessible. So if Mr. Scott were to make a demand today, the clerk would be able to cut a check and get that money to him within a few days. But if that money were transferred to the treasurer, it would greatly expand that time period. There would also be a cost associated with transferring those funds back and forth.
But going back to notice, if I recall correctly, Mr. Scott had testified that he, in fact, did not receive services summons. Am I remembering that correctly?
Well, Your Honor, his argument before the lower court mostly fixated on where those funds were being held.
Right, but I believe that the trial court indicated that Mr. Scott had said that he did not receive it, And he basically credited Mr. Scott with that. He believed Mr. Scott.
Mr. Scott,
Aren't you in essence asking us to put aside the credibility determination made by the trial court when it comes to notice?
well, this is being reviewed de novo, so I am asking you to kind of accept all these facts new and do your own evaluation. Mr. Scott never provided an affidavit.
Under what authority are we to then look at the facts de novo?
All issues of law are reviewed de novo.
Right, but you asked us, you are asking us to review the facts de novo as well as what I understood, or are you not? Maybe I misunderstood.
I am, Your Honor. So in Altman v. Parker, this court, which was a 2018 decision out of this court, it is very similar facts to this. And in that case, the defendant claimed that he did not receive notice. However, in that case, he provided an affidavit and a background on why he did not receive notice. So here, all Mr. Scott did was say, I didn't receive notice. I didn't receive notice. At the lower court, he was represented by counsel, and they could have produced an affidavit or some facts on why he did not actually receive notice. But instead, he merely stated, I did not receive notice. In Altman v. Parker, this court also states that it is an evaluation where you look to the defendant and what they say, but it should also be evaluated and balanced with the circumstantial evidence. And here, the docket is very clear and very strongly states that he was receiving notice at 617 Worcester Pike.
Well, isn't that what the trial fact always, I mean, that's what the trial fact is to do, and we're going to assume that the trial court understood the law that applied and with regard to determinations of fact. So the trial court explicitly says that he accepts Mr. Scott's testimony that he did not receive notice, and he makes the factual determination that notice was not received.
Well, again, Your Honor, the opinion of the lower court is quite ambiguous, because she goes through and she states, well, you must have received notice of this because you were here. You must have received notice of this because you appeared here. And then she somehow comes to the conclusion that notice was not received. So it is very ambiguous. And again, it doesn't follow the requirements of Civil Rule 4. And where those requirements are followed, notice is presumed proper unless rebutted with sufficient evidence by the defendant. The defendant introduced no sufficient evidence. He merely stated, I didn't get notice. But again, the circumstantial evidence highly disputes that when he appears at court twice and lists his address of service in his objections. And again, it is not required. The lower court found that he did not receive actual notice, but due process does not require that the defendant receive actual notice. It's only necessary that notice be reasonably calculated to inform interested parties. And based on the docket.
And, to your point of notice, I don't know if you noticed this, that the actual a copy of the notification that was mailed out says that it's being provided pursuant to ORC section 2329.44. So it pulls it out of the statutory section that you're rooting your argument in.
I apologize. What do you mean rooting my argument in?
Well, 2329.44 is, while it does govern foreclosures, it's a different statutory section.
It is, Your Honor, and that's actually an interesting point because 572120 governs delinquent real estate. And if you compare 2329 and 572120, only 2329.44 requires that long, lengthy requirement on service of those excess funds. Interestingly enough, 572120 doesn't include any such requirement as that. But the courts have historically provided that notice because we are a system of due process. But 572120, which does govern this case and is the statute this case was brought under, it does not include that, that notice requirement.
Ms.
Well,
Daly, you are at your time unless the panel has any follow-up questions.
I did have one more question. With regard to the order of distribution or the entry of distribution of sale, it says that the balance is at the clerk of courts to be held until further order by the court. So in there, it's not stating that the balance is being held for the Scotts or for the property owner or for the alleged owner. It just says it's being held, which I find interesting because that also is deviating from 5721.20, which is saying that it's supposed to be held for the proper owner.
That's correct, Your Honor. And perhaps this is a new process, these delinquent funds. When we started this process, not that many years ago, it was completely brand new. And perhaps your point is well taken. Perhaps the way this process is done could use some revising, but that does not subtract the fact that he received proper notice of these excess funds. He failed to make a timely demand within those 3 years from their receipt with the clerk. And because of that, they should be automatically forfeited to the land bank. And it's because of that, Your Honors, we are asking you to correct the decision of the trial court and order that these funds be dispersed to the land bank. Thank you.
Thank you.
Sorry, I did have a question.
Oh, yes, I apologize.
And I know you were trying to get to it, and we've been kind of bombarding you with a lot of questions, this argument, which is fine, but the idea of strict compliance with the statute, you were trying to explain why it's more advantageous for the clerk of court to hold the money rather than the treasurer. And I'm just trying to understand if, you were trying to explain the reasoning for that and why it is that the treasurer doesn't have like a separate account where this money would go rather than the clerk. Because I know that was a big argument below, correct?
It was, and that was a big issue based on the date of receipt. The appellee was claiming that the date of receipt had not occurred yet because the funds had not been transferred to the treasurer. And I would also notice that it is more advantageous to the appellee than it is to the clerk. It would require extra work on their behalf to transfer the funds, but it's more expensive and costly for the appellee, because if he did make if he did make a claim, a proper timely claim to those funds, they would then have to be transferred back to the clerk, and the clerk is who cuts that check. There would also be a court cost associated with each of those transfers. So it would actually be more costly to the appellee as well.
Okay, so if the funds were, if there was strict compliance with the statute, there would be some sort of account in the treasurer office where the money would go to be held. And what you're saying is that if there's a claim made to the money, it would have to be transferred to the clerk of court to cut a check. It wouldn't be
Correct.
right. Okay, so they're
correct. The funds would come from the clerk. So you're essentially doing 2 unnecessary transfers as opposed to this internal agreement that the clerk just holds those funds on behalf of the treasurer.
Okay, thank you.
Yes, thank you. Thank you, Your Honors.
Very much for your argument this morning. We will take the case under submission, give you a timely written decision.
Thank you.
Ms. Hayden, thank you. Ms. Hayden, if you will bring the next parties into the courtroom. Good morning, counsel. The next case on our docket this morning is Pioneer Automotive versus Steve Rasabi. Mr. Crawshaw is here on behalf of appellant. Mr. Jansen is here on behalf of appellee. Mr. Crawshaw, you will have 15 minutes to argue this morning. Would you like to reserve any time in rebuttal?
I would, Your Honor, if I could have 5 minutes, please.
All right, I will keep your time and whenever you're ready.
Thank you, Your Honor. Your Honor, there's 5 issues I think are appropriate to discuss in relation to this case. Of course, the court is free to interrupt me at any moment. First, I think we have the question of we have a void judgment in this case. I think that's pretty clear. I think that the voidability, or the fact that the judgment is void, is apparent on the record from the record that was before the court originally. Would be my second one. Third is that it perhaps was not immediately apparent, but it became apparent with Mr. Brewer's filing of the motion to vacate the default judgment, was that Pioneer Automotive LLC is an interloper in the case. It was never it had no contractual arrangement with Village Gate. And so it really never was a proper party here.
Let me interrupt you because I want to go back to that first point that you made. You're arguing, as I understand it, that it's a void judgment because there was never proper service. Is that your argument?
Yes, Your Honor. And in fact, there really never was an attempt at proper service.
But isn't that waived? Service can be waived.
Well, it can be. The Ohio Supreme Court decision on the Skyway case that police cites, it can be waived going forward, but it doesn't. The waiver doesn't relate back. If you have a void judgment for failure of service, there's no relation back. It's going forward. And in this Ohio Supreme Court, the Skyway case, the appellant there waited, I think it said a year. The court at paragraph 16 says Skyway had entered an appearance in the underlying case and did not raise any jurisdictional objection until almost a year later. So that's a very different situation. And so my fourth point would have been, where do we go from here as far as waiver moving forward? Obviously, Village Gate has entered an appearance and is a party. So I think the effect on remand, that it should have to proceed and go through the litigation, it has waived at this point. But the waiver doesn't relate back to when a void judgment was taken. That's sort of the point. In fact, there's ample authority for just the fact that if there's no service, then there never was a valid judgment to begin with. And in this case, the failure of service was apparent on record. That was before the magistrate, before there was even a judgment here. The service was upon a street address where every bit of information within the complaint was to a suite within the service address. So we don't need to get into the whole Rule 4 requirement that the service reflect the identity of the person to whom it's served. And so there we have all these COVID-19 cases where the postman the postal worker accepts service on behalf of someone. Here, we just had service to a street address without the suite number, when in fact, throughout all the evidence that's attached to the complaint itself, everything reflects the street number. A suite number.
Did your client ever? Go ahead, Judge Kratz.
Maybe it's going to be the same issue. I'm troubled by the fact that this was not raised before the judge in the Rule 60B argument to set aside the judgment. Service was never raised. It was never an issue.
Yes, ma'am. That's true. Mr.
So
Brewer did not raise
waived at that point.
Well, it's raised going forward. I don't think you waive going back, because that's the difference between a voidable judgment and a void judgment. If you don't have service.
Did your client present any evidence under oath that he didn't receive service, that it didn't receive service? There's nothing in our record that would say he didn't receive service. Everything is that he did.
I don't think there's any. I think pretty clearly from the correspondence that Mr. Jansen attached to the complaint and the motion for default judgment and stuff like that, I think Mr. Rasabi had actual knowledge, but Mr. Rasabi was dismissed from this case. So this isn't a case about Mr. Rasabi. This is a case about Village Gate. Now, I think the evidence is going to show that Mr. Rasabi is a member of Village Gate, and I think he may even be the manager.
He's the managing member, isn't he? Isn't he the managing member?
I don't think there's evidence of that, Your Honor. And even if it was, That still doesn't vitiate the problem with the void judgment. You don't, if the clearly the address of Village Gate is of an office, and of course we've liberalized the definitions of where things can be served. It has an office in the jurisdiction, and that office has a suite number. It is, but yet there was no attempt to serve it at the suite number, and there's no signature, there's no identification of something that happened there. So I don't
One
think
final question on this point. Didn't your client admit that it had service, actually knew that the motion for default had been filed, knew of the case?
Well, that goes back to the question of actual knowledge versus service. And the case law is pretty clear that you have to have both actual knowledge and service. And the old cases back from when I learned civil procedure was that the proper approach of a party had to be, if you enter an appearance, before we had special appearances and we had all that develop, you shouldn't enter an appearance unless you're prepared to go forward. You were supposed to just not appear, allow a void judgment to be taken against you and litigate that. That was 40 some years ago. We've liberalized that, but that still doesn't change the fact that in addition to actual knowledge, you have to have service. And I think older people tend to think still in terms of, I wasn't served, therefore I'm not a party to the case. So it doesn't really matter about actual knowledge. It's still void. There has to be the compliance with Civil Rule 4, and there was no really an attempt at that other than sending it to a street address and then saying, oh, we have service, we have judgment.
Well, you're not arguing, are you, that there always has to be a street address? For example, if somebody sent me something at our building, they don't have to say the 12th floor in order for it to get to me, do they? Or the suite number or anything like that. It can still get there properly under Rule 4.
Well, if you know who signed it, if you know who accepted it, then you can go into that question of whether they were actually served and whether they were an authorized agent for service. But we don't have any of that here. All we have is
a signature. We have a signature. We don't have any testimony that says it isn't agent of your client.
Well, what we have, Your Honor, is a couple marks on the service receipt. Not a signature. There's no way to identify a person. And so the question then would become is, don't we have to have some way identifying who the person is? There's no way to tell who this is.
Once service is proper under the rule, isn't the burden on your client to present evidence that it
is it proper under the rule?
Service?
Proper under the rule says send it to the address.
I would say, well, that's where you and I may differ. You say it's not address unless you put the suite number on it.
Or you can identify who received it, Your Honor. If you that would be an equally valid proposition. But to say, well, I sent it to that street number and somebody signed for it, it's if they served it to your building, you don't know who accepted it, and you say, well, that's controlling. And I know some of the vexatious litigators try and do that. They send things to people where there's no way to identify who received it and why, and then they say, oh, I'm entitled to judgment against you because the taxing system is invalid, and therefore all your taxes that you've imposed on me have to be refunded to me, and things like that. There is that line of thinking, but I think all the courts have clearly rejected it and do not accept the whole concept of, if you can't identify the person, the fact that it went through. If you recall the B.B. Rebozo case when I was in school, President Nixon's friend B.B. Rebozo, who had a private island, and the process server swam out to the island, threw the complaint and the summons onto the beach, and the security services picked it up, and he had pictures of them picking it up. They say, okay, well, that service served to B.B. Rebozo. And then we have the cases where people were flying over the state, and they would serve, the process server would hand them the summons and complaint in the airliner while it's flying over the state. We've done away with that, but not completely. We still have to have a valid service of the process. And so I think that's the problem here.
And you are at your time if you'd like to reserve 5 minutes.
Thank you, Your Honor.
Mr. Jansen, you have 15 minutes.
Your Honor, good morning. May it please the court. I'm Gus Jansen. I'm representing the appellee, Pioneer Automotive. This entire appeal is based on non-existent facts and arguments that were not raised in the court. They don't appear anywhere in the record. The only place they appear is in the brief that was filed by the appellant. It's the first time any of this has been discussed. To the first point, there is a return of service. It's document number 7 in the transcript. It says that they were effectively served at the address that is in their statutory agent, at the Secretary of State's office. I personally sent it to Mr. Rasabi, and as this court did note, there is an affidavit from Mr. Rasabi in the record that indicates that he is the manager and sole member of Village Gate LLC. I sent it to his counsel after they filed their bad faith duplicative lawsuit in municipal court to tell them that they needed to dismiss that lawsuit and file an answer in this case. And in fact, in the record, there is a letter to their counsel before I filed the motion for default, begging them to file an answer in this case and appear, and they refused. So
counsel actually responded to you that he was not representing them in the common pleas court case, right?
That's exactly what he said. And he said, don't bother me with this, basically, and I don't know how long I'm going to represent them in the municipal case. The reality is they were dragging my client through municipal court and rushed an eviction hearing through while this case was pending for the purpose of harassment. So we had to go down to the eviction docket while this case was pending. So they knew all of this. They knew all of this. I mean, I've never seen anything like this. The arguments of counsel that the presumptions are flipped on their head and that we're going to start assuming that people who have a return of service from the clerk of court's office have not actually received it would grind our judicial system to a complete halt. There is a presumption that arises when the clerk says you got good service. The burden is on them. They knew about the case and had counsel for this matter and chose to do nothing. More importantly, all of the arguments that are made, this whole timing thing, the case law is completely to the contrary. When you enter an appearance in a case, whether the Teeters case, for example, that I cited to the court, it was a pro se defendant who did nothing more but send a letter to the court after the default judgment had been taken, and that was considered an appearance where he had failed to raise a defect with service. And so that case by itself rejects exactly what is being argued here. The defendant in this case, Village Gate, filed a notice of appearance. They filed a 60B. They filed 2 affidavits, and they filed a reply, and then showed up at the hearing by counsel, argued the entire motion, admitted receipt of the complaint in the hearing itself, and never mentioned the word jurisdiction. I can't think of a more complete concept of waiver than that.
What were their grounds that they raised in setting aside the judgment?
Your Honor, that might have been perhaps one of the more infuriating parts of this case. The sole argument really that was made, and keep in mind, we're here on a 60B5 motion. They did not appeal the judgment. They could have appealed the judgment. They filed the 60B after the judgment was taken, but before the time for appeal had expired. They chose to go 60B5, and that is their exclusive grounds. Their argument was that in the bad faith litigation matter that they filed, I get a call, and my client's furious. My client is furious that he's got all these additional legal fees. We filed this case, that it takes longer in common pleas to get through in the municipal or in the eviction docket. I get an email from their counsel asking in the municipal case if he can get 2-week extension of time to respond to our counterclaim in that case, because I filed the same thing as compulsory counterclaim in the municipal case. He said, I'm buried with all these COVID things. I'm like, sure. Professional courtesy, absolutely, go ahead. You can have 2 weeks. That is their grounds. for setting aside the judgment in the common pleas case, even though the default hearing had not even occurred yet. They could have showed up. I mean, it is, again, to use my professional courtesy with an angry client who probably would have preferred that I say no in an incident like that and say, you file it today, forget you. And then try to use that as a grounds for prejudice in the other case when we're demanding they dismiss that case completely. It's beyond argument. The most important part that we have to keep in mind is all of this is occurring in the context of a 60B5 motion, which this court has recently addressed in the Kids Bop case. Couldn't be more similar in terms of the reasoning of that case as it applies here. There's a lot of other things. I don't know that the court, you've raised them yourself. You can't be raising all of these issues for the first time on appeal. There's absolutely no factual basis to any of the arguments in this brief. You can't find them. They were invented for the purpose of this brief. And maybe that's a result of having 4 different attorneys on the case and having a different appellate one than the one who actually argued the motion. But they didn't even pull the transcript from the actual default hearing. Where we offered the evidence and had an expert appear, that's not even in the record. They didn't pull it. So as we sit here today, you have a litigant who has so completely thumbed its nose at the judicial system with actual knowledge, with an actual intent to do so, to create all of the legal fees that my client has paid for this. And now, once it all thrown back based upon non-existent record and arguments that were never made below, I don't believe there's good grounds for this appeal. And I not only should the court affirm the decision denying the Rule 60B5 motion, but it should award fees to my client.
You didn't ask for that, did you?
I did.
Any questions, any further questions from the panel? Mr. Crusher, you have 5 minutes remaining.
Thank you, Your Honor. A couple things. One, we actually have the transcript of the default judgment. It's not a record in the case because the notice of appeal obviously was filed before I got involved. The default judgment, I think, is 10 pages. The only witness is Mr. Jansen's client. It doesn't have an expert. They relied upon an affidavit from the expert that was filed in the case. There's no the only real testimony is Mr. Jansen's client. But I don't see how.
Do you agree that the default judgment transcript is not part of our record?
Yes, that's correct, Your Honor.
Okay.
It was never ordered by my predecessor counsel. As far as the no factual basis for any of the assertions in the brief, I think the court can find that I certainly did not include any facts that were not a record, just as with the transcript. And this sort of this litigation plus the case that Mr. Jansen raised that's also going on in here, there is certainly an issue about the rhetoric and the tone and the allegations that are made against counsel personally. When I first received his brief, I considered going to confront him in person. I subsequently drafted a response brief, which I threw away rather than filing with the court. The allegations that are made by counsel, really, this is so reminiscent of Eric Dieter's when he was first getting suspended by the Kentucky Supreme Court.
Counsel, I'm going to stop you there. Please make your arguments on the legal issues that are before this court, and not any personal comments on counsel.
Oh, I'm just responding to the statements that Mr. Jansen's made here in the hearing, Your Honor. I frankly wasn't going to raise it, but if he wants to do that, I'm happy to do so. But regardless, the Teeters case was a 12th district case, and he cites it in his brief. The court there, I think, is frustrated by a pro se party. It starts off with the full discussion of how you can't convert a void judgment into a avoidable judgment, but then citing the Skyway case and a case called State versus Athens, State ex rel Athens County versus Martin, jumps to an assertion that somehow you can convert a void for lack of jurisdiction issue into a voidable, and I'm not quite, they don't explain quite how they got there, that you can waive available defenses, which of course would be consistent with the Skyway case, but it seems to apply it going backwards instead of going forward. Waiver really can't be backwards. You have to, there's no doubt that after Village Gate appeared in this case, they certainly can't assert a lack of jurisdiction moving forward, but to assert that that a decision jumps backward somehow, and if that's how Teeters is being interpreted, I think that that's a wrongful, an incorrect decision by the 12th district. And maybe I'm just misreading it because it's a very short decision, and it doesn't really address the question of how do you jump from a void judgment and turn it into a voidable one and say it was waived. The Ohio Supreme Court case is real clear. You can't come in a year later and say you never had good service on me, but there's no such similar fact pattern here. Yes, we do have a presumption of service, but when the failure of the service is apparent on the face of the complaint, that is, the service was not made at the address that's reflected throughout the complaint, then I think the presumption has to fail, and the trial court should have granted the 12b-5.
Just want to make sure I understand your service argument. Your argument is that because the suite number was not included in the address, that on the face of it, that's an improper address, and the scribble signing is, we can't tell who it is, and we should declare that that's improper service even without any evidence in the record from your client that it didn't receive service.
I believe the affidavit of Mr. Rasabi is pretty clear that he was not served. Now, it's clear he knew about it, but there's really the two elements to having jurisdiction over a party. They have to know about it, and you have to have service on them. So I don't think that affects it at all.
All right, thank you.
And just for clarity, are you saying that the service is not waivable or was not waived in this case?
I think, well, if it's not, I think it's not waivable going forward. I mean, it is waivable going forward, but not going back. When there was no attempt to serve a party at the address that clearly was known, then there never was service. There never was a valid Rule 4 compliance.
All right, and you are at your time, unless the panel has any other questions. Thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion. That will conclude the oral arguments this morning for the First District Court of Appeals.